I was staring at the certified letter in my hands when I realized the Ridgeview HOA had just made the biggest mistake of their lives. They were threatening to foreclose on my house, over $8,347 in unpaid dues, fees, and fines I never knew I owed. My name is Marcus Webb, and I inherited my grandfather's property in Larkspur, Colorado, 3 years ago. The sprawling ranch house sat on what I thought was a modest 5 acres of beautiful mountain views and pine trees. I'd been living here peacefully, working remotely as a software engineer, enjoying the quiet life away from Denver's chaos. That was until Karen Westbrook became HOA president 6 months ago. The letter detailed a laundry list of violations. Apparently, my fence was the wrong shade of brown. My truck was parked in my driveway for more than 48 consecutive hours, which violated some obscure bylaw. I'd failed to submit my landscaping plans for approval before planting wildflowers in my own yard. Each violation came with a fine. Each unanswered notice came with a late fee. The fees had compounded with interest I never agreed to pay. I grabbed my phone and called my lawyer, Tom Davidson, who'd handled my grandfather's estate. "Tom, I need you to look at something. The HOA is putting a lien on my house." "Slow down, Marcus. Which HOA?" "Your grandfather's property was never part of any homeowner association. I made sure of that when we went through probate." That statement hit me like cold water. "What do you mean it was never part of an HOA?" "Your grandfather specifically fought to keep his property independent. The Ridgeview HOA formed in the late 90s when developers started building around his ranch, but he refused to join. They tried to force him into it through several lawsuits, but he won every time. His property rights predated their incorporation by decades." I looked at the letter again, my hands starting to shake with a mixture of anger and something else. Anticipation, maybe. "Tom, they're claiming I owe them over $8,000. They've apparently been fining me for months. Do not pay them a single cent. I'm coming over tomorrow morning. In the meantime, dig out your grandfather's property records. There should be a large filing cabinet in his office. Find everything related to property boundaries and land surveys." After hanging up, I went into what used to be my grandfather's office. I'd barely touched this room since moving in, keeping it as a sort of shrine to the old man. The oak filing cabinet stood in the corner, and I started pulling out folders. Deeds, surveys, water rights documents, easement agreements. My grandfather had been meticulous about record keeping. Then I found something interesting. A hand-drawn map from 1987 with notes in my grandfather's distinctive handwriting. The map showed property boundaries that extended far beyond what I'd assumed were my 5 acres. I found another folder labeled Original Land Grant and pulled out documents that made my heart race. My great-great-grandfather had purchased 847 acres in 1923. Over the decades, portions had been sold off, but according to these records, my grandfather still owned 312 acres at the time of his death. 312 acres. I'd been living here thinking I owned just the immediate area around the house. I spread out a modern survey from 2019, one of the last documents my grandfather had commissioned. The boundary lines were marked in red. My property formed an irregular shape that wrapped around the entire Ridgeview Hills development. The housing development, with its 67 cookie-cutter homes, sat like an island in the middle of my ranch. The developers in the late 90s had apparently purchased what they thought was independent land from a company called Mountain Vista Development. But looking at the chain of title documents, I saw something that made me laugh out loud. Mountain Vista had only purchased an easement for road access through my grandfather's property. They never actually owned the land they built on. This had to be wrong. I spent the next 3 hours cross-referencing documents, looking for the mistake I was sure existed. But everything was consistent. Survey after survey, deed after deed, they all told the same story. The Ridgeview Hills development was built on my land. How had this happened? I found correspondence between my grandfather and various parties. In 1998, Mountain Vista Development had approached him about buying 75 acres. He'd refused. They'd offered more money. He'd refused again. Then they'd asked for an easement to access a parcel they claimed to own beyond his property. He'd granted it, for a fee, but they'd never owned that parcel. According to a letter from 2001, my grandfather had discovered the development already under construction. He'd immediately filed suit. The documents showed a complex legal battle that had lasted 3 years. In the end, there was a settlement agreement. I read the settlement carefully. Mountain Vista Development had agreed to pay my grandfather $15,000 per year for 99 years in exchange for a long-term land lease. They admitted the development was on his property, but claimed moving 67 families would be unconscionable. My grandfather, perhaps tired of fighting or perhaps just pragmatic, had agreed to let them stay under strict terms. The terms were clear. The development company would pay the annual fee. The homeowners would have no legal claim to the land under their houses. If the development company ever dissolved or failed to pay, all rights would revert to the landowner with no exceptions. And here was the kicker. No homeowner association would have any authority over the landowner or his property. I checked my bank records. I'd been receiving automatic deposits of $15,000 every January for the past 3 years, marked as Ridgeview Land Lease. I'd assumed it was some kind of agricultural lease payment and had never thought much about it. The payments were still coming. Mountain Vista Development, or whoever had bought them out, was still honoring the agreement. Tom arrived at 8 the next morning with his briefcase and a serious expression. I had coffee ready and every document spread across my dining room table. "I spent all night going through these," I said, gesturing at the papers. "Tom, I think my entire neighborhood is built on my property." Tom spent 2 hours reviewing everything while I paced nervously. Finally, he sat back and removed his reading glasses. "Marcus, your grandfather was a shrewd man. This is one of the most ironclad property agreements I've ever seen. You don't just own the land under your house. You own the land under every house in Ridgeview Hills. So what do I do about the HOA?" Tom smiled, and it wasn't a pleasant smile. "We're going to enjoy this. First, we're going to respond to their Lien notice with a cease and desist. Then we're going to file a countersuit for harassment and fraud. And if they push this to court, we're going to explain to a judge that they have no authority over you because they're all tenants on your property. Will that actually work?" "Marcus, according to these documents, you could theoretically evict all of them if Mountain Vista defaults on the lease. The HOA has no legal standing whatsoever. They're not even supposed to exist according to the original settlement. Your grandfather specifically prohibited any organization from claiming authority over his land. Over the next 2 weeks, things escalated quickly. Tom sent a formal cease and desist letter to the HOA, along with copies of the relevant property documents. He explained in clear legal terms that I was not now, nor had I ever been, a member of their HOA. Any fines or fees they'd assessed were void. The lien they'd placed was fraudulent and would be challenged. Karen Westbrook's response came 3 days later, and it was breathtaking in its arrogance. She refused to acknowledge the property documents, claiming they were forgeries. She insisted that all properties in Ridgeview Hills were subject to HOA authority as outlined in their CC and articles, covenants, conditions, and restrictions. She demanded I pay the outstanding balance within 7 days or face foreclosure proceedings. Tom actually laughed when he read it. She's doubling down. Perfect. File this somewhere safe. It's going to be Exhibit A when we sue them for legal fees. But Karen wasn't finished. 2 days later, I came home from grocery shopping to find a bright orange sticker on my front door declaring my property in violation of multiple HOA codes. There was also a notice that my water and trash services would be suspended due to non-payment of HOA dues. That was a mistake on her part. The water line that served Ridgeview Hills ran across my property. My grandfather had granted an easement for it, but according to the documents, interfering with the landowner's utilities was grounds for immediate termination of that easement. As for trash service, I paid for that directly through the county, not through the HOA. I called Tom. They just threatened to cut off my water, photograph everything, save every email, every letter, every notice. Karen Westbrook is building our case for us. The next HOA meeting was scheduled for a Thursday evening. I wasn't invited, of course, but I'd become friendly with my neighbor, Doug Patterson, who thought the whole situation was ridiculous. Doug had lived in Ridgeview Hills since the development was new and remembered my grandfather as a fair man who mostly kept to himself. Doug called me after the meeting. "Marcus, you need to be careful. Karen spent 20 minutes ranting about you. She's claiming you're trying to defraud the HOA with fake documents. She's convinced half the board that you're running some kind of scam. They voted to proceed with foreclosure and to sue you for the cost of their legal fees. They're going to sue me. It gets worse. She's proposing a special assessment on everyone in the neighborhood to raise money for the legal battle. $2,000 per household. People are furious, but she's convinced them that if they don't fight you now, you'll try to take everyone's homes." The irony was almost too much. They were taxing themselves to fight the person who actually owned their land. The lawsuit landed in my mailbox on a Monday morning. The Ridgeview Hills Homeowners Association was suing me for fraud, filing false documents, harassment, and emotional distress. They were seeking $150,000 in damages, plus legal fees. The complaint painted me as a con artist trying to undermine the community for personal gain. Tom filed our response 2 weeks later, and it was a thing of beauty. Not only did we deny all their claims, but we filed counterclaims for harassment, libel, fraud, and breach of contract. We also filed a separate motion to dissolve the lien and impose sanctions on the HOA for filing a frivolous lawsuit. Our response included 47 pages of supporting documents, deeds, surveys, the original settlement agreement, payment records, and correspondence proving that my grandfather's property rights had been established and recognized for decades. We also named Karen Westbrook personally in the countersuit. If she wanted to play hardball, we'd show her what hardball actually looked like. The preliminary hearing was set for 6 weeks out in Douglas County Court. Judge Patricia Morrison was assigned to the case, a no-nonsense jurist with a reputation for having little patience for BS. In the meantime, the harassment continued. Karen filed a new violation complaint every few days. My grass was too long. My trash cans were visible from the street. My doormat was the wrong color. I had moss growing on my roof. Each complaint came with a new fine, usually between $200 and $500. I documented everything but didn't engage. Tom had advised me to let her dig her own grave, and that's exactly what she was doing. Then Karen made a critical mistake. She sent a letter to all Ridgeview Hills residents explaining the lawsuit and asking for additional donations to the legal fund. In the letter, she made several defamatory statements about me, claiming I was a con artist, that I was trying to steal their homes, and that I had a criminal record. None of it was true, and she'd put it all in writing. Tom immediately added the letter to our evidence file and amended our complaint to include additional libel charges. 3 days before the hearing, Karen's lawyer withdrew from the case. I learned this from Doug, who heard it from someone on the HOA board. Apparently, once the attorney had actually reviewed all the documents Tom had filed, he'd advised the HOA to settle immediately. Karen had refused, so he'd quit. The HOA scrambled to find new representation and ended up with a young attorney named Brad something who'd passed the bar 6 months ago. Tom actually felt bad for the guy when we met at the courthouse. The hearing was held on a cold November morning. The courtroom was small, and Judge Morrison looked like she'd rather be anywhere else. Karen sat at the plaintiff's table with young Brad, who had the unmistakable look of someone who knew he was about to lose badly. Tom and I sat opposite them. Judge Morrison called the case. This is the matter of Ridgeview Hills HOA versus Marcus Webb with corresponding counterclaims. I've reviewed the filings from both parties. Counsel, I have questions. She looked at Brad. Counselor, your clients placed a lien on Mr. Webb's property for unpaid HOA dues. What is the basis for the HOA's authority over Mr. Webb's property? Brad stood up, fumbling with his notes. Your Honor, all properties within the Ridgeview Hills development are subject to the HOA's CC and Articus, which were filed with the county in 1999. Mr. Webb's property falls within the development boundaries. I've reviewed the documents submitted by Mr. Webb's counsel. Are you aware that Mr. Webb's property predates your client's HOA by over 70 years? Your Honor, we dispute the authenticity of those documents. Judge Morrison's expression could have frozen water. You dispute the authenticity of recorded deeds and surveys that have been on file with Douglas County for decades. On what basis? Brad floundered. We believe they may have been altered or misrepresented. Have you filed any motions to challenge these documents? Have you hired a forensic expert to examine them? Have you presented any evidence whatsoever to support this claim? Not yet, Your Honor, but we intend to. Counselor, you can't just claim documents are fraudulent without evidence. That's not how this works. She turned to Tom. Mr. Davidson, walk me through the property history. Tom stood and launched into a clear, concise explanation. He described how my great-great-grandfather had purchased 847 acres in 1923. He explained how the property had passed through generations, with portions sold but the core ranch maintained. He detailed the 1998-2001 legal battle and the resulting settlement agreement. Your Honor, the settlement agreement is particularly relevant here, Tom said. It explicitly states that no homeowner association would have authority over the landowner's property. The HOA's own founding documents were required to include language exempting the original ranch property, specifically the parcel now owned by Mr. Webb. Judge Morrison looked at Brad. Did you review the HOA's founding documents before filing this lawsuit? I reviewed the current CC and Articus, Your Honor. The current ones, have they been amended? Brad looked at Karen, who whispered something to him. We're not certain, Your Honor. This was getting painful to watch. Judge Morrison ordered a recess and demanded that both parties return after lunch with copies of the original HOA founding documents. During the break, Tom and I grabbed sandwiches from a deli across the street. She's going to rule in our favor, Tom said. The question is how harsh she'll be about it. What happens to the HOA? If the founding documents contradict the settlement agreement, which I'm confident they do, the entire HOA structure might be invalid. At minimum, they'll be prohibited from exercising any authority over your property, and the lien will be dissolved. We returned to court at 1:30. Brad had somehow obtained a copy of the original 1999 HOA incorporation documents. Tom already had multiple copies. Judge Morrison spent 20 minutes reading through them. Finally, she looked up. The original CC and Articles, filed in November 1999, include Section 2.3, which explicitly exempts the Webb family ranch property from all HOA authority. The exemption is clear and unambiguous. It describes the exempted property using the exact same legal description as the current deed held by Mr. Webb. She turned to Karen. "Miss Westbrook, are you an officer of this HOA?" Karen stood. "Yes, Your Honor, I'm the president." "How long have you held that position?" 6 months, Your Honor." "Did you review the HOA's founding documents when you took office?" Karen hesitated. "I reviewed the current bylaws and CC and Articles, but not the original incorporation documents. I was told they were the same, Your Honor." "Who told you that?" "The previous president, Linda Martinez." Judge Morrison made a note. "Miss Westbrook, did you personally approve placing a lien on Mr. Webb's property?" "Yes, Your Honor. He failed to pay legitimate fines for violations of our community standards. Standards that don't apply to his property according to your own founding documents." "Miss Westbrook, did you send a letter to residents of Ridgeview Hills making accusations about Mr. Webb's character and claiming he had a criminal record?" Karen's face went pale. "I sent a letter explaining the situation to homeowners who were being asked to contribute to the legal defense fund." "Answer the question. Did you claim Mr. Webb had a criminal record?" "I may have mentioned that we were investigating his background. Does he have a criminal record?" "I don't know, Your Honor." "So you told your neighbors that Mr. Webb was a criminal without knowing whether that was true?" Karen sat down, and I could see her hands shaking. Judge Morrison spent several minutes writing notes. Then she delivered her ruling. "This case is one of the more clear-cut property disputes I've encountered. The facts are not in dispute. Mr. Webb owns property that has been in his family for over a century. The Ridgeview Hills development was built on a portion of that property under a long-term lease agreement between the developer and Mr. Webb's grandfather. The HOA was explicitly prohibited from exercising authority over the Webb family property." She looked directly at Karen. "Miss Westbrook, you placed a lien on Mr. Webb's property without reviewing the basic legal documents that govern your organization. You made defamatory statements about him in writing. You assessed fines and fees you had no authority to collect. This is not a borderline case. This is not a good faith dispute over ambiguous language. This is incompetence bordering on malice." Brad tried to stand. "Your Honor, if I may sit down, Counselor. I'm not finished." Judge Morrison turned back to her notes. "The lien placed on Mr. Webb's property is hereby dissolved and declared void. The Ridgeview Hills HOA is permanently enjoined from exercising any authority over Mr. Webb's property or assessing any fines, fees, or dues against him. All previous fines and fees are declared void and unenforceable." Tom squeezed my arm. "We'd won, but Judge Morrison wasn't done. Regarding the counterclaims, I find in favor of Mr. Webb on all counts. The HOA is liable for harassment and filing a frivolous lawsuit. Miss Westbrook is personally liable for libel based on the letter sent to neighborhood residents. I'm awarding Mr. Webb $25,000 in damages and full attorney's fees, which will be calculated and submitted within 30 days. Karen looked like she might faint. Brad was scribbling notes frantically. Furthermore, Judge Morrison continued, I'm ordering a full audit of the Ridgeview Hills HOA's finances and governance practices. Given the apparent lack of proper oversight, I want an independent examination of how this organization has been operating. The audit will be completed within 60 days at the HOA's expense. She looked at Tom. Mr. Davidson, please prepare findings of fact and conclusions of law consistent with this ruling. I want them filed within 2 weeks. Yes, Your Honor. One more thing. Judge Morrison's expression was stern. Miss Westbrook, I strongly suggest you consult with an attorney about your personal liability in this matter. Your actions went beyond simple negligence. If Mr. Webb chooses to pursue additional civil claims against you personally, he would likely succeed. Consider this a warning. The hearing was over. We stood as Judge Morrison left the courtroom. Karen and Brad huddled together, speaking in urgent whispers. I could see tears forming in Karen's eyes. Outside the courthouse, Tom shook my hand. That went even better than I hoped. Not only did we win, but she imposed sanctions and ordered an audit. The HOA is going to be in chaos for months. What happens now? Now we wait for them to pay the judgment. If they don't, we can place a lien on the HOA's common property and assets. We'll also get our attorney's fees, which will probably be another $15,000 to $20,000 given how much time I've put into this. I felt relieved but also slightly guilty. Tom, those are my neighbors who'll have to pay for this through their HOA dues. Your neighbors should have paid attention to who they elected as president. Karen Westbrook caused this mess through her own arrogance and incompetence. Maybe it'll teach them to be more careful about HOA governance. Over the next few weeks, the fallout from the court ruling rippled through Ridgeview Hills. Karen resigned as HOA president 3 days after the hearing. The board held an emergency meeting and elected Doug Patterson as interim president. Doug's first act was to apologize to me publicly and promise that the HOA would immediately comply with all court orders. The audit, conducted by a forensic accounting firm, uncovered several concerning issues. Karen had been spending HOA money without proper authorization, including $3,000 on a community relations consultant who turned out to be her sister. She'd approved contracts with vendors who overcharged for services, possibly in exchange for kickbacks. The audit found nearly $40,000 in questionable expenditures over her 6-month tenure. Doug called me one evening. Marcus, we need to talk. The audit results are worse than we thought. Karen basically treated the HOA like her personal slush fund. The board is considering filing criminal charges. Criminal charges, embezzlement, fraud, maybe theft. The amounts are significant enough that the DA might be interested, but I wanted to let you know before we went that route. This is going to get ugly. I thought about it. Part of me wanted to see Karen face consequences for what she'd done. But another part just wanted to move on with my life. Doug, I'll support whatever the board decides. She tried to steal my house over made-up violations. If she was also stealing from the HOA, that's a matter for the DA. The board voted to refer the matter to the Douglas County District Attorney's Office. An investigation was opened in early December. I gave a statement about the harassment and the fraudulent lien. Other homeowners came forward with their own stories of Karen's behavior, unexpected fines for petty violations, aggressive threats, and financial irregularities. In January, Karen Westbrook was charged with 2 counts of embezzlement, 1 count of fraud, and 1 count of filing a false lien. The false lien charge was a felony in Colorado, carrying potential prison time. Her lawyer negotiated a plea deal. Karen would plead guilty to the embezzlement and false lien charges in exchange for dropping the fraud charge. She was sentenced to 18 months in prison, with all but 6 months suspended, and ordered to pay restitution to the HOA and to me personally. She ended up serving 90 days in county jail and was released on probation. I heard through Doug that she'd moved out of Ridgeview Hills and was living with her mother in Colorado Springs. Her husband had filed for divorce. As for me, I finally took the time to really explore my property. Those 312 acres my grandfather had held onto included some beautiful land. There were hiking trails, a year-round creek, and meadows full of wildlife. I'd been living on a ranch and treating it like a suburban lot. I found my grandfather's journals in his office, written in neat handwriting that covered 30 years. He wrote about fighting the developers, about refusing to sell out when everyone around him was cashing in on the Front Range real estate boom. He wrote about wanting to preserve something real, something connected to the land and to history. One entry from 2003 stood out. Mountain Vista wants to buy me out again. They offered $2 million for the whole ranch. I told them no, money isn't everything. This land has been in our family for 80 years. It'll be here long after I'm gone. Let Marcus figure out what to do with it. He's smart. He'll understand what it means. I did understand, finally. This wasn't just 5 acres and a house. This was a legacy, a piece of the West that hadn't been paved over and subdivided into oblivion. My grandfather had fought to preserve it, and he'd been clever enough to force the developers into an agreement that recognized his rights, while letting those 67 families have their homes. The annual $15,000 lease payment was his way of making sure future generations would know the truth. Every year that money would arrive, a reminder that the land under Ridgeview Hills belonged to the ranch. It wasn't about the money. It was about maintaining the principle. I decided to honor that. I wasn't going to try to evict anyone or cause problems. The people living in Ridgeview Hills were good people, for the most part. They just had the misfortune of electing a tyrant who hadn't done her homework, but I also wasn't going to let anyone push me around again. I had Tom draft a formal letter to the new HOA board, laying out the property situation clearly. I explained that I had no interest in interfering with their community, but I also wouldn't tolerate any future attempts to assert authority over my property. I offered to meet with the board quarterly to discuss any legitimate concerns about how my land use might affect their neighborhood. Doug and the new board accepted gratefully. We established a good working relationship. When they wanted to repave the main road through the development, they came to me first to make sure the work wouldn't interfere with my property rights. When I wanted to clear some dead trees near the property line, I gave them advance notice and made sure the tree service didn't block their streets. It turned out that respectful communication worked a lot better than liens and lawsuits. I also started researching what my grandfather had actually done with all that land. I found receipts for timber sales, grazing leases to a local rancher, and even a contract with a film production company that had used the property as a location for a Western movie in the 90s. The ranch had generated income for decades, not just from the development lease but from careful, sustainable use of the natural resources. I decided to continue that tradition. I reached out to the rancher who'd leased grazing rights and renewed the contract. I hired a forestry consultant to assess the timber on the property and develop a management plan. I even contacted a local hunting outfitter about the possibility of offering guided elk hunts on the property during the fall season. Within 6 months, the ranch was generating nearly $30,000 a year in income on top of the development lease payment. It wasn't enough to quit my day job, but it was meaningful. More importantly, It connected me to the land in a way I'd never experienced before. One Saturday morning in May, almost a year after the whole HOA mess had started, I was hiking one of the back trails when I came across an old cabin. It was a small structure, maybe 12 by 14 feet, built from hand-hewn logs. The roof was half collapsed, but the walls were still solid. I pushed open the door carefully and found myself in what had clearly been someone's hunting camp. There was a stone fireplace, a rough wooden table, and shelves built into the walls. A metal box in the corner contained yellowed newspapers from the 1940s and some old photographs. One photograph showed a young man in army uniform standing in front of this same cabin. I turned it over. The back read, "Henry Webb, home on leave, August 1944. That was my grandfather, decades before I was born, looking impossibly young and serious. Another photograph showed Henry with a woman and a small boy. Henry, Dorothy, and Jack, summer 1952. Jack was my father who died when I was 12. I'd never seen this picture before. I sat on the cabin floor and went through the entire box. There were letters, receipts, hunting licenses, and more photographs. My family's history, preserved in this forgotten cabin on land I'd almost lost to an HOA that had no right to it in the first place. That night, I started making plans to restore the cabin. It would be a project, something to do with my hands while my mind worked through code and algorithms. But more than that, it would be a way to connect with my grandfather and the generations before him who'd worked this land. I hired a contractor who specialized in historic preservation. We spent the summer carefully restoring the cabin, replacing the roof with period-appropriate materials, chinking the logs, and rebuilding the fireplace. I had electricity run out to the site and installed a small solar panel system. By September, the cabin was functional again, a perfect retreat for weekends when I needed to get away from screens and keyboards. The Ridgeview Hills HOA situation became something of a legend in Douglas County. Tom told me that several of his attorney friends had used the case as a cautionary tale about the importance of due diligence in property law. A local newspaper ran a story about it with the headline, "HOA Learns Expensive Lesson About Property Rights." I was contacted by 3 different HOA reform organizations who wanted to use my story in their advocacy materials. I agreed, hoping that maybe it would help someone else who was facing similar harassment. Karen Westbrook finished her jail sentence and disappeared from public view. I heard rumors that she'd moved out of state, but I never confirmed them. I didn't particularly care. She'd faced consequences for her actions, both legal and personal, and that was enough for me. The $25,000 judgment from the lawsuit was paid by the HOA's insurance company. My attorney's fees, which ended up being $18,000, were also covered by insurance. I used the money to fund the cabin restoration and to make some needed repairs to the main ranch house. 2 years after the whole mess started, I was sitting on my deck one evening when Doug walked up my driveway. We'd become genuine friends over the months, bonding over our shared appreciation for how absurd the whole situation had been. "Got a minute?" Doug asked. "Always. Want a beer?" "Definitely." I grabbed 2 bottles from the fridge and we sat looking at the sunset over the mountains. "The board wanted me to talk to you about something," Doug said. "The lease with Mountain Vista Development is set to renew in 3 years. The company was bought out by a national real estate investment firm last month. They've sent us notice that they're considering not renewing the lease." I felt a chill despite the warm evening. What does that mean? It means in 3 years, if they don't renew, all rights revert to you according to the original settlement agreement. You would have the legal right to terminate the lease and reclaim the land. Doug, I'm not going to evict 67 families. That's insane. I know, and we know. But the investment firm might be using it as leverage to renegotiate the terms. They might want you to agree to a permanent easement or to sell them the land outright. I wanted to give you a heads up before they approach you directly. I thought about it. What does the HOA want? Honestly, we want to know that our homes are secure. A lot of people have lived here for 25 years. They've raised kids here, built lives here. The idea that some investment firm might decide to walk away and leave everyone in legal limbo is terrifying. Let me talk to Tom. There has to be a solution that protects everyone. Over the next few weeks, Tom and I worked through various scenarios. The investment firm did indeed contact me, through their lawyers, proposing that I sell them the land under the development for $2.5 million. It was a substantial offer, enough that I could have retired early and traveled the world. But it felt wrong. This land was my family's legacy. More importantly, I'd come to realize that the arrangement my grandfather had created was actually brilliant. He'd preserved his property rights while allowing the community to exist. He'd generated income without exploiting anyone. He'd maintained leverage to prevent exactly the kind of abuse that Karen Westbrook had attempted. If I sold the land, that balance would be gone. Some investment firm would own it, and homeowners would be at their mercy. If I refused to renew the lease, 67 families would face an impossible situation. Tom and I drafted a counter-proposal. I would grant the homeowners a 99-year lease for a nominal fee of $1 per year per household. The lease would be recorded against each individual property, giving the homeowners security. In exchange, they would acknowledge my ownership of the underlying land and agree to reasonable restrictions on development and land use. The investment firm would be cut out entirely. They could either pay my grandfather's original lease rate to maintain the common areas, roads, and utilities, or they could transfer those responsibilities to the HOA directly. But they would have no special rights or claims. I presented the proposal to Doug and the HOA board. They were stunned. "You're essentially giving us permanent rights to the land our homes sit on for nothing," one board member asked. "For $67 a year and respect for basic property rights," I corrected. "My grandfather fought to keep this land in our family, but he never wanted to hurt innocent people. This arrangement protects everyone except corporate landlords looking to extract maximum profit." The board voted unanimously to accept. The investment firm tried to negotiate, but when they realized they were going to lose their leverage, they agreed to transfer the common area maintenance responsibilities to the HOA and walked away from the lease entirely. Tom spent months working out the legal details, but by the following spring, every homeowner in Ridgeview Hills had a recorded lease giving them secure, long-term rights to their property. I maintained ownership of the underlying land, the undeveloped acreage, and any mineral or water rights. But practically speaking, the homeowners had everything they needed. The story had a strange epilogue. About 3 years after everything was settled, I received a letter from a law firm in Boulder. They represented a Karen Westbrook who was seeking to have her criminal record expunged and wanted me to provide a letter supporting her petition. I called Tom. "Is she serious?" "Technically, she's within her rights to ask. Colorado law allows for record sealing in certain circumstances after someone has completed their sentence and probation, but you're under no obligation to support it." I thought about it for a long time. Karen had tried to steal my house. She'd defamed me, harassed me, and caused me months of stress. She'd also embezzled from her neighbors and abused her position. But she'd also served her sentence, paid her restitution, and presumably spent 3 years thinking about what she'd done wrong. Holding on to anger forever seemed like it would hurt me more than her. I wrote a carefully worded letter. I explained what Karen had done and the impact it had on me. I also noted that she'd completed the terms of her sentence and paid what she owed. I said I neither supported nor opposed her petition, but that I believed in the possibility of redemption if someone genuinely worked to change. I never heard whether her petition was granted. I hoped, for her sake, that she'd learned from the experience and was living a better life. But I also didn't particularly care either way. She was no longer part of my story. As for me, I was living a life my grandfather would have been proud of. I was working the land sustainably, maintaining my family's legacy, and building relationships with my neighbors based on mutual respect rather than coercion. The ranch was thriving, the cabin was restored, and I'd found a sense of purpose I'd never had during my years in corporate software development. I even started dating someone I'd met at a forestry conference, a wildlife biologist named Sarah, who appreciated the way I was managing the property for both productivity and conservation. She introduced me to the idea of placing some of the undeveloped land into a conservation easement, permanently protecting it from subdivision while providing tax benefits. 5 years after the HOA tried to put a lien on my house, I was sitting in that restored cabin with Sarah, planning where to put hiking trails and wildlife observation points. The sun was setting over mountains my family had looked at for 4 generations. Somewhere down the hill, 67 families were living their lives in homes that sat on my land, secure in the knowledge that their rights were protected by lease agreements that honored both history and fairness. I thought about my grandfather's journal entry about how he'd trusted me to figure out what the land meant and what to do with it. I think I finally understood. It wasn't about ownership in some abstract legal sense. It was about stewardship, about being a temporary caretaker of something that would outlast me and pass to whatever future generations came next. The HOA never bothered me again. Doug served as president for 3 years before passing the job to someone else, and we remained good friends. New people moved into Ridgeview Hills, and the story of how their neighborhood came to exist on leased land became part of the community's folklore. Some found it unsettling, but most appreciated the unique arrangement that gave them security without the predatory practices of corporate landlords. I expanded my work with conservation groups and became an advocate for rural property rights and responsible land management. I gave talks about my grandfather's fight to preserve our ranch and the creative solution he'd engineered that protected both property rights and community interests. The annual lease payment of $67 came like clockwork each January, 67 separate checks from 67 households. I deposited them in an account dedicated to land maintenance and trail improvements that benefited everyone. It was never about the money. It was about the principle, about maintaining the truth of who owned what while treating everyone fairly. Tom retired from active practice, but remained a friend and occasional advisor. He liked to joke that our case was the highlight of his career, the perfect combination of clear law, compelling facts, and a satisfying victory over bureaucratic overreach. One fall afternoon, I was leading a hiking group across the property when someone asked how I'd ended up with so much land. I told the story, starting with my great-great-grandfather's purchase in 1923 and ending with the HOA's attempt to foreclose on my house over made-up violations. "So you could have evicted all those people?" someone asked. "Legally, maybe, but that was never the point." My grandfather spent years fighting to protect his rights, but he also agreed to let people stay once they were already here. He understood that property rights come with responsibilities. Just because you can do something doesn't mean you should. What happened to the woman who tried to foreclose on you? She went to jail, paid restitution, and moved away. I hope she learned from it, but I honestly don't know. I was never interested in revenge. I just wanted her to stop trying to steal my house. The group laughed, and we continued up the trail toward the meadow where elk often gathered in the early evening. This was my life now, showing people the land my family had protected, sharing the story of how sometimes standing up for your rights means fighting back against bullies with badges and bylaws. The ranch would be here long after I was gone, just like my grandfather had written. Someday I'd pass it to my own children if I had any, or to some other family member who would understand what it meant and what it was worth. The land would endure, the legal protections would remain in place, and 67 families would continue living their lives on property that belonged to someone else but felt like home. That was my grandfather's real genius. He'd created a situation where everyone's interests were aligned. The homeowners wanted security and stability. I wanted to preserve my family's legacy and be left alone. The arrangement he'd negotiated gave us both what we needed without requiring trust or goodwill. It was all written down in legally binding documents that had withstood decades of scrutiny. When Karen Westbrook tried to impose her petty tyranny, she ran face first into a property rights structure that was older and stronger than her little fiefdom. The judge hadn't needed to be convinced or cajoled. She'd simply read the documents, understood the facts, and applied the law. Justice wasn't some abstract concept in our case. It was right there in black and white, recorded in the county clerk's office for anyone who bothered to look. That was the real lesson. Do your homework, know your rights, keep good records. Stand your ground when you're right, but be willing to find creative solutions that serve everyone's interests. My grandfather had done all of that, and it had saved not just his land but also my house decades later when I'd needed it most. I'd inherited more than property. I'd inherited wisdom, foresight, and a model for how to live with integrity in a world that often rewards corner-cutting and bullying. The HOA tried to steamroll me because they assumed I was just another powerless homeowner. They learned expensively that assumptions can be dangerous when you're dealing with someone who knows the law and has the documents to prove it. As the sun set in Sarah, and I locked up the cabin for the night, I felt a profound sense of gratitude. Grateful for my grandfather's stubbornness and strategic thinking. Grateful for Tom's legal expertise and friendship. Grateful for Doug and the reasonable people who'd taken over the HOA and turned it into something functional. Grateful for the land itself, still wild and beautiful after all these years. The HOA had tried to put a lien on my house for unpaid dues. Instead, I'd shown a judge that their homes sat on my ranch, that their entire community existed at my family's sufferance, and that the petty tyrant they'd elected had no power whatsoever over me. It could have been a disaster. It could have ended with evictions and lawsuits and decades of bitterness. Instead, it ended with clarity, with everyone understanding where they stood and what they owed to whom. It ended with fairness, with homeowners getting security and me maintaining my rights. It ended with justice, with Karen Westbrook facing consequences for her actions while everyone else moved forward. Most importantly, it ended with the land still in my family's hands, protected and preserved for whatever future might come. That was all my grandfather had really wanted, and it was everything I'd fought for. We'd won, not through force or wealth, but through the simple power of being right and having the documents to prove it. The lights of Ridgeview Hills twinkled below as we drove back to the main house. 67 families, living their lives, probably never thinking about the unusual arrangement that governed their property rights. That was fine. They didn't need to think about it as long as they treated me with the same respect I showed them. I'd learned something important through this whole experience. Property rights matter. Community matters. The law matters when it's applied fairly. But more than anything, integrity matters. My grandfather had maintained his integrity by fighting for his rights while still treating people fairly. I tried to follow that example, and it had worked out better than I could have imagined. The ranch was mine, all 312 acres of it, with 67 houses sitting on a small portion under a lease agreement that benefited everyone. The HOA had learned a painful but necessary lesson about the importance of understanding the law before wielding power. I'd learned that standing up for yourself can lead to better outcomes than quietly accepting injustice. And somewhere, I like to think my grandfather was satisfied that his legacy had been preserved, and that his grandson had proven worthy of the trust he'd placed in him. The land would endure, the arrangement would protect future generations, and the story would be told and retold as a reminder that sometimes David really does beat Goliath, especially when David has better lawyers and a century of property records on his side. That was how an HOA's attempt to foreclose on my house for made-up violations turned into a victory for property rights, common sense, and the kind of creative problem-solving that benefits everyone involved. It wasn't the story I'd expected to live when I inherited my grandfather's ranch, but it was the story I got, and I wouldn't change a single thing about how it turned out.